Hi, it's Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer. Today I'd like to talk a little bit about trusts and asset protection. And can trusts protect your assets? If you have any questions about a Northwest Indiana estate planning or probate matter, you can always give me a call, or you can set up an appointment and we can meet by phone, video conference, or in person. You can go to indianaestatemeeting.com to go ahead and do that. So this is a misunderstanding by a lot of folks. A lot of folks believe that if they go ahead and put stuff into their trust, that stuff in their trust is actually protected from creditors. And as a general rule, the answer is no. But like most things with the law, we have to go ahead and we have to define certain things. Because when most folks talk about trusts, they talk about a revocable living trust or an RLT. And then there's the other flavor of trusts, which are irrevocable trusts. So a trust, just as a refresher, is an agreement between the grantor, the person who establishes the trust, and a trustee. And the document will set forth certain rules for holding property and then maybe later on distributing property after somebody passes away. And the way that you can look at a trust is you can say, well, a trust is sort of a box. And there's different types of boxes, right? If you buy a box of paper from Office Depot, a lot of times the box will have a cover that you're able to take off. So you can use the box for storage without the cover on top. And that is a open box. And so RLT, or Revocable Living Trust, is a box where you can go ahead and title and put your stuff in there. But because it is a revocable living trust, you have the ability, as the grantor, the person who established it, if you kept that ability, to go into that box and to do anything that you want with the stuff in the box. You can give it away to somebody, you can take it and sell it, you can keep the money, you can take it and title it back out of the trust, you can do whatever you want with the stuff. And because you're able to do whatever you want with the stuff, it is not subject to asset protection. Why? Because the general rule is this: if you are able to get at the stuff is subject to somebody from the outside, whether it be a creditor or a predator, to go after into the box and grab the stuff. So a revocable trust in which you're able to do all that stuff provides no creditor or predator protection. On the other hand, if you set up some controls in your trust where you or somebody that you're trying to protect is unable to reach into the box and take stuff out to them directly, take principal out directly, sell things in the trust directly, liquidate things in the trust directly, then it's sort of a closed box, right? We put the cover back on the box. And so when it's a closed box, it's an irrevocable trust. And at that point in time, creditors cannot get into the box because there's a cover on the box. You see, the person that you're trying to protect, whether it's you or a kid or a spouse, they cannot go into the box and take the stuff out directly. They have to do some other things in order to get the stuff out of the box. So the general rule is, if you have access directly to stuff in the trust, It is not protected from creditors, lawsuits, predators, anybody else. But if you do not have the direct ability to take stuff out of that box and to liquidate it, then there is asset protection. If you have any questions about a trust, you can always give me a call. I am Guy DiMartino. Have yourself a great day.